All right, let's go back on the records and we'll call next case is People versus Wyndham Rieger. It's file 24-6853FH. Counsel, want to state your appearances, please?
Melissa Goodrich, Wayne County Prosecutor.
Luke Gusky on behalf of Mr. Rieger, Your Honor.
All right, we're here for sentencing on a charge of operating while intoxicated, third offense, a 5-year statutory maximum. Guidelines were initially scored at 0 to 9 months. Have you had a chance to review the pre-sentence report and recommendations with your client?
Your Honor, I've had a chance to review the report recommendations. We didn't have any objection to the report recommendations and no scoring challenges at this time, Your Honor.
Okay, Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
And I would note, I also did have an opportunity to review, I didn't count them, but there were probably in excess of a dozen letters of support, predominantly from the AA community, as well as documentation of AA attendance on behalf of Mr. Rieger. Thank you for forwarding that, Mr. Kukowski.
Thank you, Your Honor.
And anything you want to say on behalf of your client?
There is, Your Honor, and just briefly, Mr. Rieger finds himself in a sad situation here, being he's operating on intoxicated third offense. He was a successfully completed sobriety court just a few years ago, relapsed in this case, and here we are. What he's done since this case and since he's been pending the pendency of this, I guess, sentencing in this case, is he's started a Al-Anon meeting here in Sheboygan. He's brought that back. The community did not have one, and the AA community saw a need for it. Mr. Wyndham stood up and started a meeting, and he's passed it on to a friend of his, and they've been co-chairing that meeting, but he's been the one that started it and got it going. He attends AA regularly, almost religiously, Your Honor. He's been very dedicated to sobriety. He understands this relapse and the situation he finds himself in is very unfortunate. He's got all the nice letters that Your Honor's had a chance to review. He's had this overlink on since this offense occurred, and this offense occurred back over a year ago, April of the year. So he's not had any issues on his bond for well over a year. He started new meetings here for the Al-Anon community. He's been attending AA religiously. He's been still counseling. He's got great employment. He's got his business all tied up and wrapped up so that it can be taken care of while he's incarcerated. All those reasons, Your Honor, I think set Wyndham apart from your normal drunk driving third offender that you see in front of the court. I'm not sure I've had a client that has amassed the AA attendance, the letters, and the credentials that Mr. Rieger has. And albeit he's still on that path for sobriety, and he's still moving forward in that direction and moving forward in the right direction, Your Honor. So I'd ask the court, the recommendation and the agreement was not to exceed the midpoint of the guideline range. The guidelines are 0 to 9. The recommendation here is just the 30 days. I'd ask the court to adopt that recommendation, just send Mr. Rieger to the statutory minimum 30 days. So he can get back out and continue to provide a service to this community that is desperately needed with the AA community, the Al-Anon, and all that good stuff that he's doing, Your Honor. I'd ask the court not to overlook that because this is his third offense. Thank you.
Thank you, Mr. Contestant. Mr. Rieger, it's not required that you would say anything today. You don't have to, and if you don't, I don't hold that against you. You are also allowed to say anything you wish. Is there any statement you want to make, sir?
No, Luke said it pretty well. I'll leave it at that. Thank you.
Okay, very good. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. Thank you. The defendant is 60 years old with no prior felonies, 4 prior misdemeanors. He's self-employed with a high school diploma and 3 years of college. We're here because on April 10th of 2024, the defendant was viewed crossing the center line, having difficulty navigating curves. He did admit to consuming at least 4 beers. His blood test came back a 0.214, more than double the legal limit. The PSI recommendation is for 30 days. When looking at Mr. Rieger's history, in 2007, he had an impaired in Sheboygan and received fines and costs. In 2008, he had an OWI with 2 years probation. In 2013, he had an OWI third that was reduced to a reckless and 10 days jail. In 2020, he had an OWI third reduced to an OWI second with 1 year in jail and 2 years probation. Now we're here on this new conduct from 2024. For the first time, he is a convicted felon, but I do believe that the jail time should be more than 30 days I would recommend 3 months jail, which still would be consistent with our plea agreement for mid-guideline range. Thank you.
Okay, I'm going to assume that the year imposed in the district court matter would have been suspended when you were in recovery court. You didn't actually do a year in jail on that, right? Okay.
Sobriety.
All right, Mr. Rieger, if you'd stand for the court sentence, please. All right, well, Mr. Rieger, you're 60, you don't have any prior felonies, but you know, the prosecutor outlined your history with drinking and driving, and it's a very troubling history. We've got great letters from the AA community about your commitment to sobriety, and that's fantastic. And it sounds like you were involved with them beforehand, and they talk about your slip or your relapse and then coming back, and that's, you know, that's fine. And I'm glad you're back involved in that. That's going to be a necessary part of your success, continuing on with that fellowship. But it's important to recognize that, you know, you are not standing in front of a judge today because you had a slip, because you had a relapse on alcohol. It's because you drove while drunk. There's no addiction that makes you drive. But for some reason, you repeatedly make decisions to drive after you've been drinking. You don't strike me as somebody that wants to do harm to other people, but you could wreck somebody's life or take somebody's life every time you do this. And what's really troubling to me is, you know, the officers on the scene, when they pull you over and, you know, clearly you're not driving right, and they asked you about how much alcohol you drank, and you said, within my boundaries. I mean, somebody that's got 3 prior convictions and 4 prior arrests for drunk driving and has been through a sobriety court, to be twice the legal limit and telling an officer when he's driving that you're within your boundaries shows to me not just a relapse, but a profound misunderstanding of the nature of your disease at that time. I hope you're in a better place now, but it's tough to figure out, you know, what to do. The guidelines at 0 to 9, you know, would call for an intermediate sanction, which would mean we shouldn't give any jail unless there's reasonable grounds to do so. Here, there's a mandatory minimum 30 days, so we at least have to do that. But, you know, these guidelines don't adequately take into account, they do take into account prior history. What they don't take into account is that you keep doing the same thing. And that places people at serious risk of harm. Prior probation has not been working well. You had a treatment court, and that has not been enough to keep the community safe from Wyndham Rieger driving drunk.
Is it too late for me to say something? Or can I say
Go
something?
ahead, say something.
I said that I was an alcoholic in the past, but I didn't truly believe it until April 10th of last year, when I finally said, I am an alcoholic. And it finally clicked, you know, that.
Well, I mean, I hope that's true. I hope that's true.
That's all I want to say.
Oh. Well, and that's consistent with, you know, what I'm saying is that up until last April, you didn't really have an understanding of what was going on. So it's tough to know, you know, really what to do with you, because, you know, we've tried a lot of different things. Presuming that you didn't do much jail in recovery court, you know, it looks like the most you've done before is around a month. You have a sentence agreement for a midpoint cap. This is a true 4th conviction. There was another one where you were arrested for an DWI 3rd, pled to reckless. I don't really know a lot of the details about that, but that's a troubling driving history. So taking all those things into account, I'm going to place you on probation as recommended for 18 months. Subject to the terms and conditions listed on the pre-sentence report on pages 2 and 3. They include, I want to highlight some things, obtaining a substance abuse assessment following the recommendations, a curfew, 60 days of community service, employment, court costs of $350, crime victims assessment of $130, fine of 500, 225 OUIL reimbursement, DNA testing with a $60 fee, $68 in state cost, and a monthly supervision fee. And in terms of a jail sentence, I'm going to follow the prosecutor's recommendation for 3 months in the Sheboygan County Jail with credit for 2 days previously served. I'll indicate on the judgment that I have no objection to your participating in any jail programming, including CBT or trustee status, if the jail determines you're eligible for that. That doesn't mean you get to demand those things of the jail. Sometimes when I say that, they go back to the jail and say, how come I'm not a trustee? That's just me saying, I don't veto those things. It's up to the jail administrator what programs they want you in. But if they approve you for any of those, I'm going to have pre-approved on my end. And that can shorten your sentence.
Does that include the work release, Your Honor?
I would not allow work release. No,
You're not allowing work release during those 3 months?
I'm not.
Okay, well, I'm done working for the rest of my life.
Well, then you're done working for the rest of your life. I don't care.
Okay.
I'm not letting you out of the jail. You're serving that time and you're lucky it's only 3 months. And you're not done working for the rest of your life. You can get out and get a job. In fact, I promise you, you're not done working for the rest of your life because a condition of your probation is that you work 30 hours a week minimum. If you don't, you'll come back and do some more jail.
I guess what I meant was.
Mr. Rieger, you should consider seriously stopping talking right now. I've announced my sentence. I believe it's proportionate. It's within the guidelines. It's consistent with the plea agreement. You're eligible for early discharge from probation. If you successfully complete the terms, I'm going to hand you a piece of paper about that. If you want to appeal, you can do so. If you want a lawyer, you got to ask me within 6 months. We're going to hand you a piece of paper explaining that and ask you to initial 1 copy for me. The other one's for you to fill out if you wish to take an appeal. Within 24 hours of your release, you must have contact with your supervising agent. And I hope, and you should hope, that you don't come in front of me in violation of your probation.
Thank you, Your Honor.
Preston, do you have any other matters?
I believe that concludes my matters, Your Honor.
All right, yep.
Thank you.
You have a good day.
You too, Your Honor. Thank you.
See, Anderson and somebody on Zoom that might be Mr.